Friends, today we discuss the travesty of justice regarding the pavement dwellers. Of course, even though there is a very famous case law called as Olga, Tellis and others versus Bombay Municipal Corporation. I think 1985. The judgment was delivered in 1986. It is also called as the public interest litigation. Now, the problem here we have to discuss is the problem is like this. The district magistrate or the collector has given instructions to evict a colony people because they are staying unauthorizedly in the public land. So what is the alternative for them? As an advocate, if they approach you, what are you going to suggest? This is the problem. Definitely, you may be knowing the collector has got, a district magistrate has got every power under section 133 of the CRPC to evict persons if they encroach the land. There is no doubt, definitely. More than that, the Land Encroachment Act 1905, Land Encroachment 1995 is there. Of course, the persons who have occupied or who have encroached the government side, they can be evicted. But for both these things, please remember, they have to follow the principles of natural justice. That means they have to give a notice, take their explanation. If they are not satisfied, definitely they can evict them. So please remember, here we have to think about human rights, the right to life and right to livelihood. So the government cannot evict them abruptly unless they show some alternative site to them. The government cannot evict them abruptly unless they show some means of livelihood to them. But is it possible for the government to provide livelihood and all these things to us? It's a big debatable question. But anyway, as far as possible, because of the directive principles of the state policy on social security measures, definitely they have to help the poor and downtrodden people. Whether they are doing it or not, you may be knowing very well. Now, in this connection, so we have to cite this very famous case law, that is Olga, Tellis and others versus the Bombay Municipal Corporation 1985. This is called, otherwise called as pavement dwellers case, or the public interest litigation, because at the time public interest litigation was in the offing. That means it was in the initial stage. Whether this petition can be taken as a public interest litigation or not, all these things are there. Because Olga Tellis was a journalist. She was a social worker. She wanted to represent the pavement dwellers. Now let us go into the details of the case. Right, friends, you may be knowing Bruhat Mumbai Corporation presently. Previously, it was Bombay. In 1985, it was Bombay only. Right? At that time, even now also, 1/4 of the population, please remember, 1/4 of the population, they stay in bastis, they stay on the pavements, they stay on the public roads, particularly during the nights. That's why there is a joke. So Mr. Salman Khan was able to kill 5 persons. His vehicle could run over 5 people because the people are they are sleeping on the pavement. That is the pity in Bombay, right? So now, what happened is here. So since it is there, the state of Maharashtra and also Bombay Municipal Corporation, they wanted to evict the pavement dwellers from Bombay, pavement and slum dwellers from Bombay, because it is the economic capital, finance capital of India, and when so many foreigners are visiting, they cannot see these slums and other things, mushrooming growth of the slums in the Bombay city only. Therefore, they wanted to evict them. Right? So now Olga Tellis, who is a social activist, she stood on behalf of the pavement and slum dwellers and filed a public interest litigation. Right? Now it was, of course, luckily after discussion, the public interest litigation was taken up by the Supreme Court. Right? Now the petitioner, Olga Tellis and others, of course 11 others and 10 others, actually total 11 persons, they have claimed that Such act of removal of encroachments would violate the human rights, that is, a right to life under Article 21 of the Constitution of India. So definitely. So a home in a city, suppose normally the Bombay Municipal Corporation says that they will allot them sites in the outskirts. But please remember, a home in the city, if allowed, will make them attain their livelihood. After all, who are they? There are daily laborers, daily wage earners, or hawkers, something like that. So unless they stay in the city, it is not possible to eke out their livelihood. So a right to life and right to livelihood also. So therefore, they demanded adequate resettlement if evictions are proceeded with, because government, they can't do anything. If evictions are there, some resettlement should be there. Right? Now, the court held that a right to life under Article 21 of the Constitution includes a right to livelihood. Please remember, way back in the beginning days of human rights cases, I told you the very famous case of Munn versus Illinois, 1876, Munn versus Illinois. There, that Munn and Co. in the Chicago, they have actually so abruptly raised the price of the granary stores present cold storages, which was not liked by the government, and the government wanted to control them, and they said it is a private right. Ultimately, in this case, definitely right to life includes right to livelihood. So in this case, Justice Field, he observed that life means something more than animal existence. More than animals, just they are also living, but ours, since we are intelligent people, we have got the common sense knowledge, we have to live better than them. So the inhibition for causing the deprivation of life. So when the deprivation of life comes, if any limbs attach to it or if any facilities are taken away, then right to livelihood is also gone. That means if you take away the granary from the agriculturists, definitely the right is gone. Therefore, right to life includes right to livelihood. In this case, another judge, so his name is Douglas, Justice Douglas, he says that right to work is the most precious liberty. So right to life and liberty, right to work is the most precious, because he will have the dignity of labor. Right to work is the most precious liberty, as it enables a man to live, and a right to life is a precious freedom. This is what they have stated. Right? Therefore, the Bombay High Court, the Supreme Court, based on for so many precedents, they held that a right to life includes a right to livelihood also. Right? No doubt, the Bombay Municipal Corporation is authorized to evict the pavement dwellers, to evict the footpath, people staying on the footpaths, and to evict the people staying on the public roads. But they cannot evict the slum dwellers or basti people unless they give a notice to them. And if they are willing to go away, they should not evict them without giving them the reasonable time. Right? This is the part of judgment. Now, the Supreme Court at that time, it has postponed the eviction up to the end of the monsoon season, because there are rains at that time, the people cannot go anyway. So, till 31st October 1985, the moment of eviction should be postponed. And also, of course, at the same time, the court declined to hold that evicted dwellers had a right to get the alternate site immediately. No, they said, the Supreme Court said, take the census of 1976 and the identity people of the people who are residing there, and then only allot the alternate sites to them. Otherwise, you may be knowing, in India, everything is possible. You may be saying, the people who are having about 10 or 15 acres of land in a village, you will be having the white ration card. That is the problem with our people, right? And secondly, the Supreme Court ordered that the sites should be provided with the 1976 census, and slums which were in existence for more than 20 years should not be demolished. They should not be removed. And the third is, high priority should be given for resettlement. This case has been cited in so many subsequent cases also. Please remember, this is a very good case for pavement dweller. Thank you.